Your cross-examination.
Thank you. Mr. Menendez, when the police left your parents' home on August the 21st in the early morning hours of 1989, sometime that morning they turned the house back over to you and your brother. Is that correct?
Right.
And between that time and one incident in December when they took your mother's computer, they didn't come back and take any other of your parents or your possessions. Is that correct?
I don't know.
Well, were you aware that they had come back and taken anything out of the house?
Sustained. The answer is stricken.
Okay. So to your knowledge, the only time that you were aware that the police were at your parents' house was after you had called them there during the 911 call, and they stayed there until about 8:30 in the morning on the 21st, correct?
Not exactly sure what time. I thought it was a little later than that, but that could be correct.
Would it be before noon on the 21st?
I think so, yes.
And did it appear that they had taken very little of your parents or your personal possessions with them?
Yeah, I didn't notice that anything was missing. I'm not sure that I checked, or I'm not even sure that I went in the house and stayed in the house long either, but I didn't notice anything was missing. Right.
In the days following your parents' deaths, you stayed off and on, or you went off and on to the Beverly Hills house, correct?
Yes, very rarely, but occasionally.
Okay, who was involved in packing up the house and taking your parents' personal effects away?
My Aunt Terry. I don't remember who else, really. I mean, they had professional movers to take some things that they shipped to New Jersey, but and boxes and other things of that sort, but I'm not sure who was in charge. I assume it would be my Aunt Terry, since she's the executor, and I'm sure my Uncle Carlos, who's the executor, also was working, so she was probably there.
I believe you indicated at some point that you gathered up some of your mother's personal papers. Is that correct?
Yes, anything with her handwriting that I could see.
Anything with her handwriting that you could see?
Right.
Did you do that in regards to any of your father's personal papers?
No.
And so after the police left your house sometime before noon on August 21st, you were free to go through the house and do whatever you wanted, correct? There was no one there to stop you.
Right.
Okay. Now, I believe you indicated that in the spring or summer of 1989, your father had told you that he had disinherited you. And I believe you indicated that he said it in such a way that you thought it had already occurred. Is that correct?
Right. It was earlier than the summer, for sure. Close to the first of the year or somewhere around there. But I don't remember exactly.
Okay.
But he indicated that, yes.
Prior to 1989, had your father ever told you that he had disinherited you?
No.
So it was sometime, you think, near the beginning of the year of 1989 that your father first mentioned that he had disinherited you, correct?
I believe so. I mean, I could be off by, it could be just before 1989, it could be just after, but for some reason I don't remember the actual conversation well enough. All I remember is him saying at some point that he had taken me out of the will, and that there was no explanation.
How many times did your father tell you that he had taken you out of the will?
Just in sarcastic remarks, just a few times.
And what was the last time he had said that to you before your parents' deaths?
I think a couple of months.
Do you remember the occasion or what the surrounding circumstances were the last time your father told you that you had been disinherited?
No, I remember an argument with my brother that he had, in which he was threatening to cut off my brother at some point for something small. He was just in a bad mood. He made some comment about that he spent all this money on my brother's tennis lessons, and he was furious that my brother was not answering the questions properly, not giving him the information he wanted, something to that effect. And he made a comment that he was already out of the will, and if he kept it up, he was going to cut him off completely. But that wasn't directed to me.
But you overheard the conversation.
I was there.
So then it was your state of mind that both you and your brother were out of the will. Is that correct?
Right.
And then sometime within a few days after your parents' deaths, you became aware of the fact that the only will that anyone had found included you and your brother, correct?
Right.
Now, I believe you indicated yesterday and also in your direct examination that you did not trust Dr. Oziel because you thought he had, I think you said ego problems or a big ego or something like that.
Yes, based on the way that he handled the situation with Jamie. That's how I got that opinion.
When you say, what situation with Jamie are you talking about?
A session which I was having some problems with my girlfriend, Jamie, and I was really wanting to work them out. And so I asked if she would come with me to a session with him to work on it. And she did. So we had this session, and he was trying to help me. And I had talked to him about what I wanted to take place in the session and get her to talk about her feelings and so on. And then after she left, his reactions afterwards and what he was telling me just gave me this feeling that he thought he knew it all and very two-faced.
When was it that you had the session with Dr. Oziel and your girlfriend, Jamie?
I think like November of '88, I believe. Could be wrong about that, but I'm pretty sure.
All right, and at that time, then you were in California, correct?
Yes.
And Jamie was in California?
It was one of the times she was here. She was traveling, but she was here at the time.
Right, and when she was traveling but was here in town, where did she stay?
She stayed with me in the guest house.
All right, and your parents permitted that, correct?
Yes.
And so it was because of that encounter with Dr. Oziel in November of '88 that you decided you didn't trust him because you thought he knew it all. Is that correct?
Right.
Right. Now, were there any other things that you had, any other experiences you'd had with him where you felt that you shouldn't trust him?
Not until after the 31st.
Now, I believe we were talking yesterday before the break about the fact that you and your brother had a conversation after you left Dr. Oziel's office on October the 31st, correct?
Right.
And during that time, you were concerned because you wanted to know what your brother had told Dr. Oziel, correct?
That was one of the reasons, yes.
And you wanted to know just how much your brother had told Dr. Oziel, correct?
Yes.
Well, you wanted to know if he merely said, I was involved, or if he'd given details of his involvement, correct?
Well, I wanted to know if he had given details as to what was going on as far as the arguments and the issues and the crisis and basically the things that would explain what happened. And he said that he had not. He had just said a few specifics of like buying the guns and a few things afterwards, but no details about the issues. So, and he had just said that he hadn't told him why, and Oziel seemed to accept that.
Now, why was it that you felt that if your brother had talked about sexual abuse, that that was something that you should get angry with your brother about?
Well, I was just, a lot of my anger was that I felt like he had gone to Dr. Oziel instead of going to me. And it was more that I was sort of hurt by that, and I was feeling like, why did he do that? If he's suicidal, how come I don't know, and how come he didn't, come to me? And feeling very caught completely off guard by the fact that he had now told somebody who I did not trust, and the whole thing was very upsetting and confusing and frightening.
So you were very angry because when you went to see Dr. Oziel, you thought your brother might have told Dr. Oziel about something that would mitigate the crime, correct?
No, I thought, there were lots of reasons, like I just said all the reasons, but that reason was basically that he had told him that we were involved at all. I really was not thinking that there were things that mitigated that we were both feeling very bad about what happened. And just the only thing going through my mind is that we had killed our parents, and there was nothing that you could say about it that was good.
When Dr. Oziel explained to you the confidentiality laws and that things that you said to him would remain secret, you didn't trust him, did you? In other words, you didn't trust that he was going to abide by confidentiality,
No,
right?
I did not.
And no matter what he said to you, you didn't trust him, correct?
Well, I couldn't be, positive. He was saying he wasn't going to go to the police, and I just wasn't sure if he was genuine or not because I didn't trust him. But I really don't know what else could I do but hope that he didn't.
Now, by November the 2nd, you knew that the police hadn't come to arrest you, right?
Right.
All right. So like the evening when you waited for the police to come on August the 20th of 1989, you waited a period of time and you determined that Dr. Oziel had not gone to the police, correct?
Right.
And so you went back on November the 2nd, correct?
Right.
And during that discussion on November the 2nd, it was then that you became aware that Dr. Oziel might be able to help you, correct?
No.
So there was no time during the session of November the 2nd when you felt that Dr. Oziel might be able to put together a family history to help you later on?
He suggested that he could do that. And the only thing that I thought was good about that suggestion was that it would make him feel much more comfortable, make him feel needed and less threatened. He was feeling threatened by the way that I acted in the first session. And this would certainly put us in a relationship where we would need him and we would be trying to figure this thing out together. So in that regard, I was very relieved when he suggested that and thought it was I said, that's a good idea. But never did I really think that was going to take place.
Now, when you and your brother went home after October the 31st, and you indicated he told you some of the details of what he had told Dr. Oziel, correct?
Right.
And your brother told you that he told Dr. Oziel about the purchase of the guns, correct?
I believe so, yes.
Did your brother mention to you that he told Dr. Oziel about seeing a show or a special on the BBC?
No.
He never mentioned BBC to you, is that correct?
Right.
And what other details did your brother relate to you that he had told to Dr. Oziel, aside from the ones you've mentioned?
No details as far as conversations or issues and things of that sort, which was my concern mostly, but the purchase of the guns, the going back to the car to search the car afterwards,
The reloading.
and that I had shot my mom last. And I'm not sure what else. There may have been one or two more things. I'm sure that maybe one or two more things about the aftermath, whatever happened afterwards. I'm not sure. Probably that we dropped the guns off on Mulholland, actually. I'm not sure what else. Oh, and sorry, I'm remembering. The going to the Civic Center, I think he mentioned that too.
All right. Now, since I asked you yesterday about it, do you recall at what point during your travels the night of August the 20th it was that you took the freeway? Was that going to the Civic Center or coming back from the Civic Center?
I think that I'm going to object this misstating the evidence. I think he said he didn't remember.
Well, this is the question overall.
I believe I took a freeway, and I could guess which way I took, but I wouldn't know for sure.
All right. So your answer is you don't know.
Right.
Now, when you were talking to Dr. Oziel on November the 2nd, did you ever say anything about the murder, about the crime being perfect?
No.
So when Dr. Oziel testified to that in front of the juries, then he was telling a lie. Is that your testimony?
That's right.
All right. And I believe you testified, though, that there were many things that Dr. Oziel testified to that actually were either said by you or said by him.
Right.
And one of the things that you repeated here yesterday was the fact that Dr. Oziel told you that he felt you were menacing.
Yes.
Did you by any chance talk to Dr. Oziel about your father's theory about the Chinese Revolution and how he would have handled it?
Yes.
So when Dr. Oziel said that here in court, and he talked about what you told him your father said, he was telling the truth, correct?
Right.
And that is information that you gave to Dr. Oziel, correct?
Yes, it is.
Did you tell Dr. Oziel about the computer and the will?
Yes.
All right, so when Dr. Oziel testified to that, he was telling the truth.
No.
Well,
He was distorting it a little, but we did have a conversation about the computer and about the will. But he was trying to connect the two and draw some points that I don't think were accurate.
but Dr. Oziel did repeat for the juries what you had told him, which was that it wasn't done for money, correct?
Right.
And that is your assertion, correct?
Right.
And so when Dr. Oziel said that information, which is helpful to you, he was telling the truth, right?
Well, I'm not sure that he said anything helpful to me, but he was telling the truth about that.
Well, I believe he indicated that, I believe he repeated to the juries that you didn't do it for the money, correct?
Yes, I think he did, yeah.
And you told the juries, I think within the first 3 questions of your direct testimony, that you didn't do this for money.
Right.
So Dr. Oziel's testimony then supports your testimony, correct? In that regard.
In that regard, yeah.
Object, that's argumentative.
Overruled.
Did Dr. Oziel ever tell you during the November 2nd session that he was going to make tapes and put them someplace safe?
Yes.
And he did tell you?
No, he didn't say that. He said that he had made tapes and put them in safety deposit boxes, and there were other attorneys that knew about it.
All right, so that he did tell you, is that correct?
That's right.
All right, and did you ever tell Dr. Oziel that you felt like it was in your best interest for him to stay alive so that that information that he told you about would not become public?
Definitely, yes.
Did you make a joke to him about that?
Yes.
And what was the joke that you made to Dr. Oziel?
That I would, the way he had structured it with the tapes and so on, that I was concerned that he would, if he ever died in any strange way, that now all this about whatever my brother had said would be released. And so that if a burglar, I gave him a joke that if a burglar ever went into his home and was going to kill him or threaten him, he might see me there, or I'd have to be there to kill the burglar and protect Dr. Oziel.
All right, so you actually did say that to him, is that correct?
Something to that effect, yeah.
And that sounds very familiar to you.
Yeah, it does.
Now, at the end of your November 2nd session, did you discuss the fact that you were going to go on a trip with Dr. Oziel?
No.
Did you?
Trip with Dr. Oziel?
No, not with him. Did you discuss it with Dr. Oziel, the fact that you and your brother were going to go on a trip to Hawaii?
We may have, yes. We were planning on going on a trip, so we may have.
All right, so at that time, you were planning to go with your brother on some sort of vacation to Hawaii or someplace like Hawaii?
Right.
Okay. Now, I believe you indicated on your direct examination that Dr. Oziel repeated something which you say is untrue. And Dr. Oziel said that your father told you, you can kill me if you want to, but you won't get anything. And I think you indicated that I would be in a hospital if I had intimated that I would kill or hurt him. Do you remember saying that?
Right, and so would anybody else, I would think.
All right, now on the night of August the 17th, the night that your father got home from the trip and you had the conversation with him, you indicated to the jury that you threatened him after you felt that your plan hadn't worked, correct?
Right.
And your father did not put you in the hospital when you threatened him, did he?
No, he was going to kill me instead.
Okay, but
I didn't threaten his life, and I certainly could never make a statement like that. We were having a discussion about some very serious issues, and we were going back and forth, and I was reacting to what he was saying. But, from who my father is, and even from the little bit that Dr. Oziel probably knew about my dad, he knows when he makes that statement that it's just not possible. It's ridiculous. My father is not the type of person to give an answer like, well, you won't get the money. If somebody says something that disrespectful to him, he just goes off. He does not react in that way. It's not possible.
And yet when you told your father that you were going to expose him to the world as a child molester, he didn't put you in the hospital that night, did he?
No.
And in fact, he didn't put you in the hospital at all between the 17th and the 20th of August, correct?
No, he didn't.
Now, during the November 2nd session, did your brother ever mention the fact that your mother had been locking the door to her bedroom?
No, not in front of me.
All right, so is that something, well, was your mother locking the door to the bedroom during the period of time preceding her death?
No, but she did lock the door, so I don't know if he mentioned that.
Now, I believe you indicated, may I have a moment, please, Your Honor? I believe you indicated at one point during your discussion with Dr. Oziel that he gave you an example of two different kinds of killings, one of which was an emotional reaction to something like finding your spouse in bed with someone else or something like that. And then he described another kind of killing in which there was a great deal of, well, there was a lot less emotion, I think, would be. No? Is that-
No, he didn't say that, no.
Well, I'm paraphrasing it then. He described an emotional murder, and he described a murder that had to do with solving a problem. I think that's what you testified to on direct.
Yeah, similar. He basically described it as something where you know what the problem is. It's like an ongoing thing, and then what happened solved the problem. And mentioned something about that it was emotional, but that what happened solved the problem, and so there wasn't there anymore. Basically what he was saying.
And that particular description, the two descriptions that Dr. Oziel gave you, came after a question that you had asked of Dr. Oziel, didn't it?
No.
All right, so
He was trying to, I'm sorry, go ahead.
well, so my question is this. Did Dr. Oziel mention the term sociopath to you right before he described these two kinds of killings?
No.
And so it's your testimony that at no time during the November 2nd session did Dr. Oziel use the term sociopath. Is that correct?
No, he wouldn't have said that.
He wouldn't have said that?
I don't think he would have been talking about, I mean, sociopath is a bad word, and this, we were trying to put things, we were talking about positive things in this session because, like you said, he was saying he could help us in a trial, and he was looking for mitigating factors, and he just wasn't, there wasn't any conversation about, bad characterizations of why this might have happened.
And you were trying to put the situation in a more positive light, correct?
Well, he was trying to help us figure out why. We were saying we didn't know why, and he was trying to explain to us, why he thought it would happen, and not in a bad way.
And so when he gave you a description of the two different types of killings,
Right.
how did that happen? Did he just say, by the way, I want to give you two different types of killings and let me see which one you think is accurate? Is that how it occurred?
Basically, he was fishing for the reasons why, and then he came up with these two examples, and he just kept trying to fish for why, because we were saying that we didn't know why, and he believed that we didn't know why, and it was kind of something that just developed, and he was trying to figure out. So he gave me this one example where it was just like all of a sudden the guy had no idea what was going on. He walked into this room, found his wife in bed, or a situation where it was something that was ongoing, and there was a feeling that now whatever was there was over, was solved. And I felt that neither one was right, but it was more like the second, is what I said.
All right, so at no time did the term sociopath come up during this discussion. Is that correct?
Right.
Okay. And Mr. Menendez, if you were trying to calm him down and you were trying to help your brother, you were trying to find some sort of balance between what you knew and what Dr. Oziel knew, why didn't you just tell him we did it in self-defense? Why didn't you tell him that?
Because I didn't want to tell him why.
What did you think he was going to do if he knew that you had done this in self-defense after years of abuse?
Cause for speculation.
Overall.
I didn't think he would do anything. More than likely he would feel better. But at that point, I just felt, based on the discussion I had with my brother before we went into the session, that we would not talk about those very personal things in our life that are so difficult for Erik to talk about. And he didn't even know what would happen with me. I certainly wasn't going to talk about that. But even the other things, I'm not just talking about the stuff that happened with my dad, but even all my mother's problems, what she was really like. She was a very secretive person. That's the reason I collected anything in her handwriting, because she's a very private person. And I just didn't feel that this guy should have that information. Just didn't feel comfortable with it. It wasn't something that I wanted to just give him without any good reason.
But at that point, Dr. Oziel was the only person who knew that you and your brother had done it, correct?
Right.
He was the only person who could turn you into the police.
That's correct.
And you had an interest in making Dr. Oziel understand why you did this, so he wouldn't turn you into the police as a cold-blooded, threatening killer, but rather as a victim. Do you understand my question? You had an interest in making sure that you were portrayed in the best possible light to Dr. Oziel so that he would not feel threatened by you and turn you into the police, right?
Right. And I think at that point, by the time that he said that he could be helpful to us in a trial, which was very early on in the session, shortly after he made the joke about the Jeep thing, it was clear that he was not feeling threatened. He was in a much better mood. He was trying to piece together why this happened. He seemed fascinated. He was talking about maybe doing hypnosis with us later on. He was then talking about money matters at the end of the session. He was not afraid. I got a completely different sense from him. And I never got a sense after that he seemed threatened again. And he never told me he felt threatened again.
So during the November 2nd session, that's when Dr. Oziel talked about abuse as a defense. Is that correct? He talked about using abuse as a defense to the crime.
No, he didn't. He talked about helping in a trial, helping an attorney piece together what he called the family constellation, the dynamics in the family, that the emotions that might have led to this, in his opinion.
Dr. Oziel is the one who planted in your mind the idea of using abuse as a defense. Isn't that true?
No, ma'am.
Thank you. I have nothing further.
Now I'd like to mark 2 additional exhibits. One is a message on Princeton University paper. I've already sent the prosecution. Dated February 1st, 1989, documenting a phone call from Lyle Menendez's father to the university regarding his room. What's the next number? 253?
Yes.
And the other are medical records from the Beverly Hills Medical Center dated January 22nd, 1989, documenting hospitalization for heart problems of Jose Menendez. May I approach?
Yes.
Mr. Menendez, you had indicated on direct that you had some difficulty with regard to your housing at Princeton University when you returned in 1989,
Yes.
and you had indicated that your father had intervened. Is
Yes.
that correct? I'm showing you what we've now marked as 253. Could you take a look at that?
Yes.
Can you tell me what it indicates?
I was in Wilson College at Princeton University, and this is person that worked there, just that my father had made a call to get my room changed.
And is your father referred to as Lyle Menendez Sr. on there?
Yes.
Is that in fact his name? Was it his name?
No.
And I'm showing you what we've marked as 254. You indicated that that there was some discussion with regard to your father not being able to take a physical because of some heart problems he'd had in January. Is that correct?
Right.
Showing you 254. Ask you to identify what that is.
These are the records from the Beverly Hills Medical Center, I guess on January 22nd, 1989, about my dad's heart problem, chest pain, other problems.
Does it indicate on there the admitting diagnosis?
Acute chest pain, unstable angina.
And I'm showing you what has previously been marked as exhibit number 61. Mrs. Bazanich asked you about a letter that you wrote to Donovan Goudreau.
Yes.
Remember that?
Right.
And she asked you if that letter reflected that you were a caring person. You remember her question?
Right.
I'm showing you that. What we've marked as defendant 61 or exhibit 61. I ask if you recognize that letter.
Yes, I do.
And what is that letter?
This is the letter I wrote to Donovan.
And when did you write it to him?
It's June 18th, 1993.
You'd indicated before that in that letter you basically told him that you weren't upset with him. You knew he had to testify and that he shouldn't feel badly about it. Is that correct?
Right.
Mrs. Bazanich had asked you about the lifestyle that you had while your parents were alive. Do you remember that?
Right.
She asked you about private schools and tennis lessons and clothes and cars. Did you have all the material things that anybody could have wanted?
I think so.
Did you have everything that any kid could have wanted in your childhood?
I don't think so.
What didn't you have?
Just emotional things
Did have
and
I'm sorry.
more time to play with friends and just other things other kids do.
Did having expensive schooling and tennis lessons make up for the way you were treated by your parents?
I didn't really think about balancing it out. I was just doing the best I could.
Did it having all those material things make your childhood happy?
No.
You had been asked by Mrs. Bazanich with regard to your father's business affairs. Do you remember that?
Yes.
And she asked you some questions about how much he was making at the time that he died.
Right.
What was your understanding about what his future earning capacity was?
Well, my understanding was that he had another contract to be negotiated, I think that January. And as soon as he had settled on his second contract, the one in the spring, he came home and he was furious because he had thought he got basically screwed over and had asked for way too little because they had said yes immediately and seemed thrilled with the fact that he only wanted what he wanted. So he was going to try and renegotiate right away and basically forget the other contract and do a new one and ask for many times what he did.
And did you think he was going to get it?
Yes.
Why?
Just what he was doing for the company. I mean, for one thing, the company was heavily in debt and losing money when he was brought in. And he was the only reason that it became this phenomenally profitable company. So the owners basically give him whatever he wanted, because without him, there was no company. And with him, they made really a fortune. So, and all he was asking for was percentage of the stock and percentages of the profits that he was making. So he would only get what he made.
Did you think it was going to be much more than he was making at the time?
Well, he said he was going to ask for somewhere around the equivalent of $20 million. And he had asked for somewhere around what he thought was the equivalent of it, close to $8 million before. And so to me it was a big difference, and to him was a big difference. And then after that, I think he said he was going to stop and go back to Florida.
And you talked about the hospitalization, and you knew he hadn't taken the physical for the $5 million policy. Did you think he was going to take it in the future, or did you think he was never going to take it?
And it seemed like he was about to take it any time. I mean, the appointments were he didn't say, don't make an appointment for me, I'll take it a couple of years from now. They kept making appointments for him, and he just was giving excuses. He was too busy, I'll catch it next week, that kind of thing. And but it was that he just wanted as much time to go by as he could, really, before after his heart problem. But, he had to take the physical so he could get the policy so they could pay the premiums. So he couldn't wait forever, but he wanted to wait as long as he could.
And this information is based on what he was telling you?
This is based on arguments between he and my mother.
You talked about being told that you were out of the will. Your father had told you were out of the will. Is that correct?
Right.
Did your lifestyle change at all in terms of the money that was available to you on a daily basis after your dad told you that?
No.
So you still had tennis lessons after that?
Yeah, it was after that he was going to buy the condominium, and actually things, the family seemed to have more money as the time went on. I don't think that the will thing had anything to do with now. It was more a way of saying that he was concerned. To me, it was a way of him saying he was concerned about my girlfriends and that I needed to live up to what he wanted for me. And that included the right woman.
You told us that you were hoping on Friday that your dad wouldn't go to work. You had this conversation with him Thursday night in which you confronted him about what was happening with your brother. And I believe that on cross you said you were hoping your dad wouldn't go to work on Friday. Why was that?
Well, I was surprised and hoping, because surprised that he did go, and hoping because we just had this huge day Thursday, incredible problems and the threats back and forth, and this basically, to me, it was an issue that was going to change everybody's life one way or another, and was dangerous and so on. And it just seemed like I just was hoping that my dad was going to initiate a conversation with me in the morning and say, because we had all this happen late the night before, like after 11, he was going to come in the morning and say, hey, I've thought it over, and you're right, or something of that nature. And he just I just heard that he had left for work. I didn't even see him go, but it was sort of disheartening.
You were asked about running away. You were asked a number of times about, why didn't you just leave then? Did you and your brother discuss running away at all during this time?
Yes, we mostly discussed it Thursday night, and we may have talked about it a few other times during the weekend. But basically Thursday night, emotionally, everything that was going on, my brother was very firm that he could not leave. And
when he explained his reasons why he couldn't go, did they make sense to you?
Yes.
And whether they made sense or not, if your brother couldn't go, would you have left?
I would never have left without my brother. And I think probably there was a lot of reasons my brother felt he could not go. And I think, you have to remember my brother was he was suicidal at this point. This is why this had all started. He wanted to kill himself. It was hard to even, it took a while for him to get into wanting to survive. I got the sense that he was like, let them kill me. And that was the sense I was getting. He wasn't saying that, but that's what I felt. So he wasn't going to leave. And, he did clearly want to survive and took steps to protect himself and regained the feeling of wanting to go on. But for that one night and the preceding day, the days before, I felt like he was unsure if he wanted to go on.
When he got a little bit stronger, did he then feel he could leave?
No, he was adamant that we couldn't leave for very good reasons. But I also thought that there was emotional reasons.
Mrs. Bazanich asked you about the state of your brother's car. You had the guns in the car and whether people could see the guns or the ammunition that you had in the car. What was the back of your brother's car like?
Just similar to his room, just except for there was, nobody to help him organize it. It was basically just his car, and so it was just clothes that would just pile up day after day. If he would go to a tournament, he would bring a change of clothes after he played or whatever. Everything would just stay in the car. And if he knew he was going to play tennis or do something and then he wanted to go out with some friends that night, he'd bring a change of clothes and, a whole different outfit and just leave it in the car. And then maybe he wouldn't go out. And then things would just pile up and pile up. And essentially, since it was a hatchback, it was just this ball of stuff that was sort of strewn over into the next seat also.
So,
but all the windows were tinted also, so I don't.
So there was room in the car to have hidden guns under the clothing. Is that what you're saying? You could put.
Yeah, I don't
guns-
remember hiding them under the clothing, but certainly could have done that.
You think you had them just laying on top or of the clothing, or do you remember where they were?
Well, we brought them into the house.
But when you were moving them from like San Diego,
Yeah, they were just in the back, and all the windows were dark, and I really didn't think about it.
you've talked about or you were asked about who cleaned out the Beverly Hills house. Right after your parents died, did a number of your relatives arrive in Los Angeles?
Yes.
And do all of your relatives live outside of do you have any relatives who live in California? I think you have your cousin Henry. Is that right?
Cousin Henry?
Do you have
Right.
any other relatives who live in California?
I don't believe so.
Or right around the Los Angeles area? Any others?
I don't think so. Not that I know of.
Okay. So did all of your other relatives come from either another part of the state or another state?
Right.
And were your relatives in the Beverly Hills house after your parents died?
Yeah, my Aunt Terry and my Aunt Joan went in immediately. And everybody was in there because at some point they were working on the computer.
Did your grandmother go in?
I'm sure she did. My grandmother
And
does
your,
whatever she wants, so I'm sure she went in.
and your aunts went in?
Oh, yeah, both my aunts went in.
Did your,
Probably my Aunt Marta, too.
did your uncles go in?
Yes.
And your cousin Carlos Menendez?
I believe so, yes.
And do you know if while these relatives were in the house, they took things, they took clothing that belonged to your mom or took other personal effects?
They did take clothing.
Were you there watching what people took, or did people just sort of help?
No, I heard later from my Aunt Terry that my Aunt Joan and there's several people were, for memory's sake, wanting certain things of my mother's. And she was having a discussion with me about what we should do about that and whether we should wait first. And, you know, so I knew that people had been there taking things. I don't know what, though.
And do you have any idea how many people were in the house during that period of time, or how long they were there, or were you somewhere else?
I basically stayed away from the house and stayed away from, nobody could go into the room where my parents had been, and I just felt very bad about the house, so I didn't go. That's why we stayed in the hotel. We couldn't stay at the house.
You talked about a series of events that happened starting on Tuesday and ending on Sunday night. You've talked about that here.
Yes.
And I think at one point you said that certain events happened that for you carried real significance. They were frightening to you, but they might not be frightening to somebody else. Do you
Right.
remember saying that?
Yes.
In your years of living in the same house with your parents, did you find that it was important to try to guess what was going to happen next ahead of time?
Just say,
Did you sometimes have to make decisions or read signals?
All the time. I think probably other kids do the same thing, but for me, for sure, with regards to my parents, because of the way they were, just from my mom's facial expressions or her tone of voice or the way she moved, and my dad, for sure. My dad controlled people with hand signals, but it was more than that. You could read his face and just whatever he was doing. I mean, if he changed into tennis clothes right away, or if he stayed in his business suit, or if he went over and watched TV, or, the atmosphere changed very significantly and very suddenly all the time. So I was constantly aware of that. But it's been very frustrating trying to describe what they were like and what it was like and why I felt the way I did that weekend. And I felt frustrated through this whole thing, not being able to express that in a way that it is the same as it was.
Why would it be necessary for you to pick up cues in the atmosphere or read signals? Why would you want to do that? Why did you want to do that as a child?
Because there was not a lot of normal communication. It was a very unpredictable place, my home, and my mother especially. And, my dad could be violent or even, just I wanted his approval so bad that even just shaking his head sort of made my heart sink. So I was always on edge trying to figure out how I could avoid that.
Were you trying to read the signals this last week?
Yes.
And were you talking to your brother about what various things meant?
Yes.
And did he seem to be engaging in the same process of reading signals?
Yes.
And based on all of the things you learned about your parents in your life, in terms of their behavior, when you saw the things they were doing in that last week, did you believe that they were going to kill you?
We believed that they were.
Thank you. I have nothing further.
any recross.
Mr. Menendez, what hand signal did your father give to you before you put the gun through the back of his head and pulled the trigger?
He didn't give me any.
And what signal was your mother giving you when she was sneaking away near the coffee table before you went out and reloaded?
Nothing. I was just afraid at that point.
Okay, thank you, Doctor.
That's right. Were the signals you received signals that occurred before you went into that room?
Yes.
Anyway,
Thank you.
all right, let me see what the sidebar here just. All right, what we're going to do at this point is take a short recess and excuse the Erik Menendez jury until 11 o'clock and have the Lyle Menendez jury reassemble here in 5 minutes, and we'll resume with proceedings with the Lyle Menendez jury only, and then the Erik Menendez jury, if you would come back at 11 o'clock, and as soon as we're ready to proceed with you, then we'll do so. Again, don't discuss this case among yourselves or with anyone else, and don't form any final opinions about it. We'll see the Erik Menendez jury back here at 11, and the Lyle Menendez jury back here at 10:30.
Mr. Menendez, I believe I asked you this morning about whether or not your brother had related to you the fact of whether or not he told Dr. Oziel about a special or a show on the BBC. Is that correct?
Right.
Did a discussion or the name BBC ever come up during the November 2nd session that you had with
No.
Dr. Oziel? And when I talk about the BBC, do you know what I'm talking about?
I assume. Yeah.
What am I talking about? What do you think I'm talking about?
Rephrase the question.
What is the BBC in your mind?
I'm going to object.
It's a
Overall.
What is it?
it's a broadcasting network.
Is that the British Broadcasting Corporation?
Right.
Are you familiar with another form of BBC, another name that those initials stand for?
I'm going to object to defense of relevancy.
Overall.
They're similar to my New Jersey family's New Jersey country club initials, BBC.
That would be the Badenbrook Country Club?
Beedensbrook.
Okay. What about the Billionaire Boys Club? Have you ever heard of that?
Yes, heard of that.
All right. And had you heard of the Billionaire Boys Club before you killed your parents on August the 20th of 1989?
I assume so. I think it's an old
Oh, no.
show, an old movie.
Okay. Were you aware of the fact that it was a movie based on something true?
Yes.
And as a matter of fact, what was your understanding before your parents' deaths as to what the truth was about the Billionaire Boys Club?
I'm going to object to defense of relevancy.
Why don't you create some time frame here before we get into this?
During the year preceding your parents' deaths, were you aware of an organization called the Billionaire Boys Club?
No.
And when did you first learn about the Billionaire Boys Club?
I didn't learn about it at all, just that there was a movie about the Billionaires Boys Club, which was supposed to be about something that happened in L.A.
And it was about two murders. Is that correct? Was that your understanding of it?
I'm going to
Again, can we establish a time frame?
Okay. Did you know about the movie, The Billionaire Boys Club, before you killed your parents?
Yes, I knew about it.
And how did you know about it?
I'm not sure how I know about it. I just a movie that I'm aware of.
Did you see the movie?
No.
And you never saw it on television or any other way? Is that correct?
I may have seen it advertised on TV, or I may have somebody might have talked about it.
Okay. And who might have talked about the Billionaire Boys Club movie to you before your parents' deaths?
I really don't know. That seemed like a long time before.
Did your brother ever talk to you about the Billionaire Boys Club before your parents' deaths?
I don't know. Maybe.
Okay. In the movie, were you aware of the fact that a son participates in the killing of his father?
I'm aware of it now, but I'm not sure.
But you might have been aware of it before the killings of your parents. Is that correct?
I may have.
And were you aware of the fact that in real life, the name of the person who was killed, the father who was killed, was Eslamenia? Did you know that?
No.
Okay.
No, but I knew that Hunt was one of the kids, I believe.
And Hunt was the main defendant, correct? You knew that. Joe Hunt.
Right. I didn't know that he was a defendant necessarily, but I knew that he was supposedly, the BBC thing had to do with Joe Hunt or something like that.
And how did you know about Joe Hunt before your parents' killings?
I didn't know. It was just from the knowing about the show.
Now, on June the 8th of 1990, some paperwork was taken from your jail cell at the county jail. Is that correct?
Right.
Your Honor, may I approach, please? I have an item I'd like to mark as next in order.
I think that would be
255.
Mr. Menendez, I'm showing you a piece of paper. There's writing on both sides, but I'm going to show you the side that's got the number 255 on it. You've got some, it looks like organizational goals. Would that be fair to say that these are organizational goals for Mr. Stevens?
Yes,
Okay, so at the time that you prepared this, you trusted Glenn Stevens. Would that be fair to say?
I would say definitely, yeah.
And at one point in your life at police, you and Mr. Stevens were very close. Would that be fair to say?
I would not say very close. I would say he was one of my friends, and I didn't have many.
Right. Well, when you came out to California in March of 1990, you brought with you two people. Is that correct?
In March of 1990, right, Hayden and Glenn.
All right. And did you pay their way to come out here?
Yes,
Okay. And they were both friends of yours. Is that correct?
right.
Now, did you ever tell Glenn something to the effect of if the police ever got their hands on some tape that Dr. Oziel had, that you would be in bad shape?
No.
I'm paraphrasing.
Right, no, I remember what he said, and that's not true.
Okay, so you never said that to him?
No,
And you never gave him any money? Did you ever give him any money for the purpose of perhaps making bail or something like that?
not, not, I may have given him money when we got arrested and just given whatever money I had on me to him. And I remember that, I gave him so much money that it's really hard to know, but I never gave him money specifically for bail because I never had a bail.
Did you ever give him your attorney's card or give him the name of your attorney in March of 1990?
Before I was arrested?
Yes.
I don't think so.
Shortly after your arrest, did you ask Glenn Stevens through your girlfriend to get something out of your Porsche?
Yes, I did.
Okay, and why don't you tell us what you asked for?
Well, I knew that there were just things with my mother's handwriting on them in my car, and I didn't know what was going to happen with my car. And so I just didn't want someone, stranger to go in and get them. So I asked him if he could drop them off with my attorney, which I felt was a safe place.
Okay, why didn't you ask him to drop it off with one of your relatives?
I would have, but at that time, the only person at the house was my grandmother. And I just, they were personal things of my mother's. The reason I took them was just because I didn't know what was in them, and there were lots of things with my mom's handwriting, and she had a lot of problems in her life. I just wouldn't have handed them to my grandmother because she would have read them all.
Now, how long had you been in possession of this box of letters?
Since right after my parents died.
All right, so from late August then of 1989 until March the 8th of 1990, you had these letters, is that correct?
Right.
And you're telling me that you didn't read those letters?
No, I don't believe so. I mean, I might have looked at them and seen what they basically were, but I believe they were just from gathering them up in the house.
Did this box contain any of the writings that you had read in Calabasas?
I don't believe so, but I really don't know.
Because you hadn't read them?
I glanced through them, and I did not recognize anything like that, but it may have been.
In glancing through them, were you able to pick up what kinds of sentiments were being expressed by your mother?
No.
Was there anything in there from your father?
I don't know if it was. It would have been just picking it up accidentally because I was trying to get things with my mother's handwriting on them. But so I don't think that there is anything from my father in there. There shouldn't be.
Now, I believe you indicated earlier in the cross-examination, I believe volume 90 at page 14911, yes, at line 13, counsel, that you segregated some of the writings. Do you remember using the term segregated?
Yes.
Okay, in order to segregate them, you had to know what they were, correct?
Well, I just took, I don't remember exactly what I said there, but I had a bunch of stuff that I took from the house. Just, objects, jewelry, things of that sort, all kinds of stuff. And I believe I had it in a duffel bag and at some point was keeping it in the apartment. And then everything, I wasn't going to have the apartment anymore and I was going to ship everything to New Jersey. And I didn't feel comfortable shipping things with my mom's handwriting, so I segregated that from anything else that might have been in there.
Were any of the writings in there letters to you from your mother?
I don't know.
And aside from your mother's writings, what else was in that box?
I believe just my mother's writings.
Did you feel that perhaps if the police searched your Porsche that they might find that box?
No, I didn't think the box had anything to do with whatever the police were going to charge me with or whatever. I was just concerned about the fact that they happened to be in my car. If they were in the house, I would have just left them there probably. But them being in the car, and also the car was getting some work done somewhere or something, and so I was sort of just nervous that my mother's handwritings, and I've always been concerned after my parents died about personal things getting out. It's one of the reasons I've been very uncomfortable here. And so I've always, even from the first interview, I was concerned about what would get to the press because I just didn't want certain family members knowing my mother's problems especially, and some of my father's. So I figured among those writings, there may be things of that sort, and it'd be better just to keep them somewhere safe.
All right, so you thought that you didn't want anyone reading what your mother was thinking. Is that correct? Is that basically it?
Well, I didn't want them to know personal things about my mother that, I wasn't sure what was in there, but I just figured that whatever was in there, because she was very unstable, might be embarrassing for her or something.
And you were afraid there might be something in there as well that might lead people to believe that you had a reason to kill your mother, right?
No.
You weren't afraid of that at all when you asked your girlfriend to get Glenn to get the box out of your Porsche?
No.
Okay. And do you know where the box is now?
I believe it's in the possession of the court at this point.
Will you turn those letters over to us?
Objection, Your Honor. That's an improper question.
In regards to the last question and the last answer, the court sustains objections to both the question and the answer, and both the question and the answer are stricken, and the jury is admonished to disregard both the question and the answer.
You hadn't really read the contents of this box. You wanted to make sure that that Glenn Stevens got it from your car. Is that correct?
Right.
Okay. Now, at some time in early March before your arrest, did you call Mr. Wenskowski to inquire whether or not the Beverly Hills police had been at your restaurant?
Yes.
Okay. Were you concerned at that time that the police were in fact getting close to arresting you?
No, I had no idea.
Well, when you heard the news that the Beverly Hills police had a few days before March the 8th, gone to your restaurant in the Princeton area. Did that concern you?
I would object, this is beyond the scope.
Overall,
Yes, that concerned me.
And that's why you called Mr. Wenskowski, is that correct?
Probably. I don't know if he had left a message. I guess in just calling the restaurant, I had heard that detectives had been there and also Mr. Wenskowski with them. And nobody at the restaurant knew anything about it. So I called Mr. Wenskowski to find out, what he knew about it and what was happening.
Okay. Now, you had hired Mr. Wenskowski to be your bodyguard, is that correct?
Right.
And you'd, in fact, hired the service that he worked for to provide services for you, is that correct?
Right.
All right. Why was it that you felt you needed to have a bodyguard if, in fact, you knew who had killed your parents?
Because I was concerned with the way the media was presenting what happened and with the fact that the company had hired bodyguards for the house or, guards for the house, that some of my father's connections might think that I was feeding the police information that they would not want out. And I was concerned about that. And I expressed that to Detective Zoller, that's why I had them for the ass. And I told him.
So before August the 20th, you thought that your father was going to kill you. And after the August the 20th, you thought maybe organized crime might kill you. Is that correct?
I thought that they might try to contact us or harm me in some way. I really had no idea because I didn't think that I knew anything that anybody would be concerned about. But I certainly felt my dad may have been involved in something like that, and they might think I knew. And because of all the press saying that it was mafia and this and that, I just felt that they might think that was coming from me, and it was not coming from me. And so I made a point of telling Detective Zoller when I met with him that I didn't think it was the mafia and that I would like, unless he did, that that not get out to the press. Yeah.
Right. When was the first time that you noticed that there was a bodyguard protecting you after the death of your parents?
That I noticed or that I hired?
When did they first get hired from the Bel Air Patrol?
Oh, you mean for the house?
Yes.
I'm not sure.
Okay, and you didn't hire them, the company hired them, correct?
Right.
But when you went back to New Jersey, you hired bodyguards, correct?
Right.
Okay. Why didn't you hire bodyguards to protect you from your father?
I just didn't.
Okay, so you thought about it afterwards, but you didn't think about it before, is that correct?
Right.
Okay, now I believe you indicated that at some point you were so concerned about the mafia thinking that you might be saying things about them that you went to a man named Anthony Negri, is that correct?
That's correct.
And that was because Glenn Stevens had indicated to you that this was a person who might have been a friend or who was a friend of his grandfather. Is that correct?
I thought he said it was a friend and a business associate of his father's or past business associate. In fact, they had been involved in some company.
All right. And so when you went to Mr. Negri, it was your state of mind that Mr. Negri was representing the interests of the mafia and could somehow help you to get a message to them. Is that correct?
No, he was in the mafia. And I know Glenn said here that he only found that out afterwards, but he knew that at that point. That's why we went to see him. And he looked like he was in the mafia, and he was in charge of a security company there. So we went all the way to New York just to see him.
All right. Mr. Menendez, what does a person look like in your mind who's in the mafia?
Just from the way he talked, very rough, from the way he dressed, and they drove around in these little black Lincoln cars, and he had guys that had carried personal guns, and it just looked, and we went to a restaurant with him, and the guys there hugged and kissed him, and the son that ran the restaurant's father had supposedly been killed by organized crime, and now the son owned the restaurant. And it just seemed very much like it was the mafia. I mean, I wouldn't really know, but
Like in the movies?
yeah, like in the movies.
Okay, so did he have a Jersey accent?
I think he had a New York accent.
Okay, and he had an Italian last name, right?
Right,
And you said he drove around in a dark Lincoln, is that correct?
right.
Okay, now, and he also had people with him who were carrying firearms, correct?
Correct.
Okay, and that made you believe that he was a bona fide, true blue member of organized crime, correct?
Well, I believed Glenn. I mean, if he would have been dressed differently, that would not necessarily have said, okay, I don't believe you. He's dressed in tennis shorts, but it's just that he also fit the description.
So he fit the part, is that correct?
Right.
Now, did you want to get a firearm for Hayden Rogers so that he could bodyguard you more cheaply than Mr. Wenskowski's firm?
I don't believe so, no.
Did you want to get a gun permit for Hayden so that Hayden Rogers could protect you?
No. While we were there, Glenn mentioned something to him about whether he could help Glenn get a license to carry a concealed weapon. And he said that it was very difficult only if you were hired and working at the time. And Glenn said, well, what if I'm protecting Lyle? And you could just say I was working, and you could just say that you were paying me, and so on and so forth. And basically, the guy said no.
Now,
It'd be difficult.
this dark car, this Lincoln that Mr. Negri had, was that a limousine or was that just a regular Lincoln?
That was a town car.
All right. And during this period of time, you were traveling in limousines, is that correct?
I don't know about that period of time.
But
No, I wasn't.
do you remember Mr. Wenskowski's testimony that you and he traveled in limousines?
Yes.
Okay. And why was it you were traveling in limousines?
That was, I hired the services of D.B. Kelly, and this is what they provided. They My uncle put down a large portion of it for me, and then the rest was never paid. Just went back to the owner.
All right, and this $550,000 restaurant was what was going to help you get over your parents' deaths. Is that correct?
I don't think there's anything that's going to help me get over my parents' deaths, but certainly not the restaurant. Just give me more direction.
Did you ever think of perhaps doing something like just getting a regular old job to give you direction?
I thought about a bunch of things. I just thought about, my brother was doing something with tennis, and I was really had said that, okay, I would go with them and do that, but emotionally I was not able to concentrate and do that. So then I was supposed to go back to school, so I was thinking of doing that, and then I decided to do this. So,
Do you remember the testimony of one of your coaches that you had a discussion with him many years before where you had said you'd always wanted to own a restaurant? Do you remember that testimony?
right.
Okay, so before your father died, you had wanted to own a restaurant, correct?
That was something that was like one of my dreams was maybe to own a restaurant and make the money myself, though. He also said that it was no, I'll get it out of my dad or something like that. And my thinking was in the spring before that these were business things that I would do with my dad. He had said that he would give me whatever money was needed if we decided to do business as soon as I graduated. So when he had that conversation with me at my Aunt Terry's, I started to think about, I wonder the different things that we might be able to do. And I talked about it with Donovan, and he knew my dad had made that offer with me. And so one of the things we talked about, I believe, was restaurants.
Okay, and was this during the same time that your father told you he had disinherited you, or was it at a different time that he talked to you about opening the restaurant?
So this is the same period of time where I was out of the will, but the will thing had to do with he didn't want to eventually leave his fortune to me if I was going to be married to the wrong person, is essentially what that. It didn't have anything to do with that I was abandoned or cut off or my life was going to change as far as what he was giving me materially. It didn't have any, it wasn't related to that.
And it didn't have anything to do with the fact that when you left Princeton in the summer of 1989, you were on disciplinary probation. Is that correct? Your father?
Right.
And the fact that you were on academic probation, is that correct?
Right.
All right. And it's your testimony here today that you didn't kill your parents for the money. Is that correct?
Definitely not.
Thank you very much.
Mr. Menendez, you were asked about Glenn Stevens. Do you
Right.
remember? And Mrs. Bazanich asked you if some time prior to June 8th, 1990, you prepared a document which reflected that you trusted Glenn.
Right.
Remember? Did you trust Glenn at that time?
I trusted all the people that were close to me.
And up to that time, you trusted him?
He was a friend of mine, yes.
Did you reveal to him secrets about your family?
No.
Did you reveal to him that you and your brother had killed your parents?
No.
Did you reveal to him the fact that Dr. Oziel had made tapes of your confession?
No.
Or your conversations regarding this?
No.
So, in spite of the fact that you trusted him, you didn't tell him all of your secrets. Is that correct?
No.
Yes, that is correct, or no, it's not correct.
Yes, that is correct.
Okay. And you hadn't told anyone that you had killed your parents, with the exception of Dr. Oziel. Is that correct?
Right.
And would you have voluntarily told Dr. Oziel that information?
No.
Did you later find out additional information about Mr. Stevens which affected whether you trusted him or not?
Yes.
And did you find out information? Was Mr. Stevens running the restaurant for you when you first went to jail? Or working at your
He
restaurant?
was working there, yes.
And did you find out some information about Mr. Stevens and what he was doing at the restaurant that affected whether you trusted him?
Yes.
What did you find out?
That he was stealing.
You were asked about a limousine and losing your license. Do you remember that?
Yes.
Did your dad always travel in limousines?
Well, not everywhere he went, but there was in Pennington for a few years. It was limousines everywhere he went.
Was there any?
But then normally it would just be limousines if he felt like he didn't want to drive.
Was there a period of time in which he was using limousines because of some license problems he had?
Yes.
And when was that?
In Pennington, he lost his license, I believe, for 2 years. So he traveled. But for that reason, the company let him drive limousines everywhere.
And when you had the discussion with your Aunt Terry about a limousine, was this because of not having a driver, or the idea that you wouldn't have a driver's license?
Yes, she and I talked about my problems with the license. And essentially, I was relying on my Aunt Terry for a lot of advice on things. And she had known about what my dad had done to solve his license problems and get his license back in order. And so we discussed that. And then I just decided not to do that, basically because one of my uncles had said he thought it was a bad idea.
You were asked some questions about your interest in a restaurant.
Right.
And you said that your dad had talked about buying a fast food restaurant
Yes.
earlier in time. Do you remember what restaurant that was?
Burger King.
And do you remember who it was he was going to buy it with? Or who the discussions were with? Do you have any memory?
Well, they were with me and other relatives knew about it.
Okay. And did restaurants interest you?
Yes.
Did you kill your parents so that you could buy a restaurant?
No.
I have nothing further at this time, Your Honor.
Yes, Mr. Menendez, your father worked for the money that was used to pay for the limousines, is that correct?
Yes.
And your father did not have any inherited wealth, is that correct?
None.
Thank them, that's correct.
All right, let's get the other jury out, please. Yeah, let's get the other jury out. Yeah. All right, we have both juries back in court, and we had hoped to go on with the next witness with both juries before the noon hour, but it's already 1:45, and we wouldn't be able to get very far along. So rather than start now, I'll let you all go. I told you we would not be in session this afternoon, so let me just say a few things, and then we'll let you go for the weekend. The lawyers and I will be here this afternoon, but the juries will not. And while you're away from court, just to remind you not to discuss this case with anyone. Don't form any final opinions about it. Don't permit yourself to be exposed to anything about this case in any form whatsoever outside of the courtroom. And that means don't watch any of the television that might relate to this case. Don't listen to any of the radio that might relate to this case. Don't look at any reading material that might in any way have anything to do with this case. And don't speak with anybody that is in any way talking about this case. You must make your decision based only on what happens here in the courtroom and my instructions on the law. We've noticed recently that a few of you have been bringing the newspaper into the courthouse, into the courtroom, and perhaps into the jury room. And even the newspapers, as you might be aware by just glancing at them, have sometimes articles about this case. And it's very important that you not read those articles, that you not read the headlines even that might relate to this case. So just to follow up on that, when you come into the courthouse and come into the jury rooms and things of that nature, if you do have a newspaper with you that you want to read to occupy yourselves during the times when you're not in the courtroom, and I certainly can understand that you want to do that and keep up on current affairs and also have something to occupy yourself because there's a lot of time when you're not in the courtroom. Perhaps we can arrange for one of our trustee bailiffs to take your newspapers and remove those articles that might relate to this case and give it back to you so that then we won't have that problem. So if you want to bring the papers in, we can do that. Hopefully it won't create a problem, but we'll try to work something out where it can be done so that you'll still have some reading material and not be exposed to anything about the matter at all. So again, have a good weekend, and we'll see you all back here Monday at 9 o'clock.
From the court's comments yesterday about the giving of instruction 2.06, and from my questioning Mr. Menendez and discovering that it did not contain his own writings, but writings of other people, it was my assumption that if the court can give an instruction like 2.06, which comments on the failure to produce evidence, then that evidence does not implicate the Fifth Amendment privilege, because if the court is going to give such an instruction, that would be like giving an instruction that would be Griffin-ere, like commenting on the defendant's failure to testify, which of course can't be done. So the reasoning is if in fact these are considered to be pieces of evidence which are not products of the defendant's own thoughts or products that are compelled from him, and if the court is going to give an instruction, or the court indicated it might be in this situation of giving such an instruction, and once I established that these writings were not in fact his own, and he's not compelled to be a witness against himself with his own writings, I felt it was appropriate to ask about the box, and that's where my thinking is.
All right, and regarding the instructions, obviously we're not there yet, and the court hasn't finalized any decisions on instructions, but 2.62, I believe, is also an instruction that might deal with this area. Also, when I struck the last question and answer, thinking back on it, there might have been another question asked after the question that was the one that I intended to strike, the answer I intended to strike. The reporter will, at a break, find that colloquy. My purpose was to strike the last question of the prosecution and the last answer of the defendant, which preceded that last question, which would also call for the striking of the question that precipitated that last answer. So there's really, I believe, if my recollection is correct, two questions and one answer that will be stricken. We'll have that record found at the appropriate time and deal with it. Anything else on that subject from either side?
No, we of course don't agree with their analysis, but I think we've already made the record on that issue.
Yeah, the issue is recorded in the record here, and counsel wanted to reserve further until they had a chance to discuss the matter. This afternoon, we have other issues to resolve, and they relate to the next witness, who will be the defendant, Erik Menendez. Is that correct? Right. All right. The indication was that you have brief testimony from Detective Zoller regarding certain photographs or exhibits, and then you would be going to Erik Menendez. And there were some issues that relate to his testimony, one of them dealing with the objection by Lyle Menendez to his testimony before the Lyle Menendez jury. We can deal with that at 1:30, as well as evidentiary matters that apparently have arisen or have not yet been resolved, dealing with the scope of the people's examination of Erik Menendez as it relates to testimony before both juries or before any jury. And I have not been provided with a list of those items that were the subject of dispute. My understanding was that the people were going to do that. Well, all I know is that yesterday, for the first time, I was told that there were these issues that had to be resolved prior to Erik Menendez testifying. And the inference was that the prosecution wanted to bring out certain things that were objected to by the defense, and these were not things that had been earlier noticed to the court.
I
That's it.
There's a court called the People's Proposal made testimony of the defendants to have an unstamped copy. But we had gone through, the proposal of Beverly Hills Menendez, and we were holding back on the discussion with Attorney Erik Menendez because of the time wasn't right. So some of these issues are explained in that particular document. And then there were other issues that Mr. Curiano mentioned in passing. And we asked Mr. Curiano 2 days ago to please provide us with a list of those things that he wants to present in cross-examination, which in good faith he thinks might be controversial. And we get with them, apart from this document that we've had for several weeks.
Well, the document itself was discussed, as I recall. You're saying we didn't complete the discussions in regards to Erik Menendez?
Exactly. It was mainly to resolve the issues with respect to Lyle Menendez. And we didn't resolve the issues as to Erik Menendez, and I could indicate one of the unresolved issues, although the people don't lay it out there, they make reference to the so-called Calabasas burglaries. But one of the issues is the scope of the cross-examination concerning the Calabasas burglaries, which we entered into a stipulation on in order to avoid and to litigate those crimes. I know, and I also sort of heard through the grapevine, which is not the way to be given notice, but I did hear through the grapevine that Mr. Curiano takes the position that he should be permitted to cross-examine Erik Menendez about the statements made to Ms. Sarsic, which were subject matter of stipulation and other things by the Lyle Menendez team. So I'm really quite up in the air about what Mr. Curiano wants to pursue, but I think we should discuss it.
All right. I'll ask that, just to save the court time, I'll ask that counsel provide me with a copy of that document that you just referred to. I'm sure I have it, but I can't find it right here on the bench.
I'll give you my marked up copy. The only thing that's added to it is that on page 3, I wrote down two things in handwriting because they were also things I was hearing through the grapevine. One is Craig Heinberg, and the other is Darian and Pollock. Craig Heinberg refers to that tennis coach of Eric's that Doug Doss was cross-examined about. And Darian and Pollock are the two individuals involved in concert promotion who apparently ripped off some money from the defendants.
All right. Are these things that you feel have to be resolved before the direct examination of your client, that all of these things?
Yes, some of them certainly do. For example, I need some guidance from the court with respect to discussing the so-called Calabasas burglaries, which I don't intend to get to go beyond the stipulation, except to identify who the friend is that stipulation makes reference to. And there are there are other issues that I would deal with in direct if I know that they're going to be permissible in cross. For example, I would go into a lengthy explanation of the various housing arrangements at the county jail to show the separation between Lyle and Erik Menendez at various critical times. If the Sarsic stuff is going to be admissible against Erik Menendez. So, yes, I think that some of it should be resolved, and I think some of it can be resolved rather easily. And then I also need some guidelines about what the scope of BBC references will be with respect to Erik Menendez.
Well, a lot of these things are not going to be definitively resolved to the point of a script being prepared. This is going to be or have to be a focused discussion because, as you're aware, cross-examination is such that the prosecution is permitted a wide range in its examination, and the court does not intend to before close examination, before hearing the direct examination, and I'm not going to dictate how you conduct your direct examination by giving some binding rulings on how the cross-examination goes. It just doesn't work that way. It's there. You have to focus on specific issues, and if they are of such prejudicial nature that some fundamental right is being affected by it, then perhaps we can deal with it. But I'm not going to deal with each and every matter that might arise during the examination.
I'm not asking for any greater guidelines than the court was prepared to give, or any more specific rulings than the court gave prior to Lyle Menendez testimony. I'm looking for the same kind of determination as to what is generically and what is not generically proper cross-examination, or what requires proper extrinsic evidence proof.
All right, well, we're going to set aside time this afternoon to deal with that. All right, and rather than hearing through the grapevine or any other informal procedure, why don't you just talk to the fellow at the other end of the council table, or near the end of the council table, and he'll perhaps talk with you.
He's been very mysterious, Mayor. I tried this morning. He says, gee, I'm not going to be able to know what I want to do on cross-examination, so I don't know what we're litigating this afternoon. And I thought that was not a very...
All right, well, why don't you broach these specific subjects with him rather than with the court, see if you get an answer. All right, we'll be in recess until 1:30. And are we ready to discuss the testimony of the next witness, or the defendant, Erik Menendez?
He came up with a list of 9 items. Let me see if I could just go down the list and eliminate things that were indicated. It's important that we don't have to deal with.
I don't want to hear those. I just want to hear those that you are going to discuss.
The first item about which there is uncertainty is whether the people would be permitted to cross-examine Erik Menendez concerning the details of the Calabasas grand theft and burglary. And I have indicated to Mr. Kuriyama that the only thing I intend to do with respect to the Calabasas offenses is to
Well,
read.
why don't you just give me the list and then we'll go back.
Okay, all right, so there's details of Calabasas. The next thing is to what extent Mr. Kuriyama will be able to bring out material from the November 29th, 1989 tape-recorded conversation with Craig Signorelli that was not brought out through Mr. Signorelli's testimony or Detective Zoller's testimony about that same conversation. Our position is that we're not going beyond what was brought out. The third item is twofold, whether Mr. Kuriyama will be permitted to ask Mr. Menendez the details of the Billionaires Boys Club movie in the face of Mr. Menendez's denial that he saw that movie prior to the killing of his parents. And second, whether Mr. Kuriyama will be permitted to play the movie, which he indicates he would like to do. The next item is whether Mr. Kuriyama will be able to elicit the fact that Erik Menendez was acquainted with Brian Eslamenia, and who Brian Eslamenia is, and again, the facts of, I suppose, the killing of Brian Eslamenia's father. The next item is whether Mr. Kuriyama will be able to introduce evidence about the screenplays. I had indicated to him that I have no intention of eliciting any information about the screenplays whatsoever. The next item is whether Mr. Kuriyama will be able to cross-examine concerning the tennis coach Craig Heinberg, based on a report that Mr. Kuriyama has that indicates that at some point Erik Menendez went through Mr. Heinberg's wallet and took out a credit card and threw it into the backyard. Whether he should be permitted to ask Mr. Menendez whether he ever attacked Mr. Heinberg, whether he ever broke into his house, and other details from that report, which was shown briefly to the court. But I don't think Mr. Kuriana has a report right now, but I think he's able to obtain. And the last item was whether he could cross-examine about Erik having been basically ripped off for $40,000 by these concert promoters based on the interviews. Well, I don't know based on what. We have interviews with two people involved in this concert promotion that seem to relate statements by a member of Lyle Menendez and not Erik Menendez at all. And those are the only areas. Well, also, not to litigate it at this point, but to simply make a record, I am making a discovery demand upon the prosecution for any report prepared by Detective Zoller involving an interview with the Deputy Vera, which the people may try to use in cross-examination, which I have never seen.
Okay, those are the areas that the defense wishes to have at least discussed and perhaps ruled upon prior to the direct examination of the defendant, Erik Menendez. Are these all matters that if the prosecution goes into them, the prosecution would be doing so outside the presence of the Lyle Menendez jury?
Is that a question to the prosecution?
Yes.
Yes.
All right, so that this will only then relate to the position of the defense for Erik Menendez vis-a-vis the prosecution. Regarding the burglary and grand theft in Calabasas, what was it that you proposed to do? Are your mics on, by the way? It's there.
First of all, I don't know precisely what I'm going to ask because he hasn't given his direct examination yet.
That's understood. All of these discussions are with the foundation that we have no way of knowing the specifics of the direct examination other than the representations made by counsel at this stage.
Had indicated to this court that they proposed to ask Erik Menendez about one burglary or the grand theft of the List household, and that appears to have been their only question that they intend to ask with respect to the burglaries. I think the burglaries are also relevant in that on September 17th, 1989, Erik Menendez talks about his parents making him and his brother go to a psychologist to get some help after the Calabasas thing, as he called it. And earlier it was clarified that it was the Calabasas burglaries or robberies, as it's also been referred to. So I intended to ask Erik Menendez about the burglaries with respect to how he first came to know Dr. Oziel. And
without going into the detail of your examination, did you intend to go into the specifics of how the burglaries and thefts were committed, or just that they were things that had occurred that caused him to be with Dr. Oziel?
Primarily for the fact that this precipitated their seeing Dr. Oziel and their relationship to their parents, that their parents, after they got into this trouble doing these Calabasas burglaries, asked them to seek psychological assistance. I don't know exactly, as I've indicated, what the defense is going to get into in that regard, but it may be that I'll get into the details of the burglaries as well.
All right, but before doing so, you will give notice to counsel and the court of that intent. Okay. All right, let's go on to the next issue, the November 29th Signorelli tape. And it seems to me that that is an area that should await the completion of the defendant's direct examination. There's no way of evaluating what the prosecution might want to use from that until the prosecution hears what the defense says about Mr. Signorelli and that relationship. And it's premature at this point to go into the specifics of it.
Mr. Kuriyama, is that I intended to examine Mr. Menendez about those portions, and not all of them, but some of those portions of that tape recorded conversation that were presented to the jury. In other words, did you say this and did you say that? And obviously he will admit that he said everything that the jury heard was on that tape. And that's really all I intended to do with that. I did not intend to use it in any way to, I mean, he's going to.
Well, the tape is not all that you'll be using in your direct examination. I assume you'll be going into the relationship of your client with Mr. Signorelli, and you'll be going into other subject matters altogether that might have been touched upon during that conversation between your client and Mr. Signorelli. So to say that because you will only ask certain questions of your client in regards to that tape recording, that the prosecution should then be limited to that would be premature. I can't rule on that. I don't know what the questions will be that you'll ask your client, the areas that you'll cover that might open up areas on that tape. And I think it's premature to get into it at this point.
Well, the assumption is that unless I open something up in his direct examination that makes something in that tape relevant that has not been heretofore relevant, is my assumption always. That simply because Mr. Menendez is on the witness stand doesn't mean that anything and everything in that tape is now cross-examinable. That's my only point.
Well, obviously the normal rules of cross-examination of a criminal defendant apply. And you're aware of those limitations. When a defendant gets on a witness stand and denies involvement in the crime, the prosecution has a wide range of cross-examination, as the Supreme Court announced in People versus Ng and re-announced in People versus Redmond. And we're all aware of that. But there are limits on it, and we'll have to deal with it as it arises. I can't give you a preview of how I'm going to evaluate this evidence until I hear it. And the third item is Billionaires Boys Club. What is it that you intended to do with that?
Yeah, I believe it's highly relevant now with respect to Erik Menendez's state of mind. I suppose he's going to claim that he was acting in self-defense, as his brother has asserted and claimed. And I believe that his statement to Dr. Ozio regarding having seen this movie on the BBC will become even more relevant after Erik Menendez testifies. The movie itself is 94 minutes, and I don't think the circumstance of defendant Erik Menendez claiming that he never saw the movie should preclude the people from going into and questioning him about the Billionaire Boys Club movie. With respect to the Billionaire Boys Club movie, the item above, which is a November 29th, 1989 statement, and the item below, which is the Brian Islamania evidence, all ties into the Billionaire Boys Club movie, in as much as Erik Menendez on November 29th is talking about forming this corporation in which 4 or 5 trusted friends, including Craig Signorelli and Brian Islamania, would be members. He makes a statement that, or Craig Signorelli at one point makes a statement that this sounds like the BBC, at which point Erik Menendez says, yeah, it's like the BBC, and then goes on to talk about his friend Brian Islamania as being another member, and also talks about having to get a Rolex watch so that they could set themselves apart from the common folk, I suppose. That Erik Menendez says we have to get a Rolex watch, which you could only get through a mail order. It's a blue that fades into black. So he's setting himself up with this corporation involving some trusted friends, being Craig Signorelli and Brian Islamania and 2 other young men. And I think that ties into the Billionaire Boys Club and him having seen this movie as related and testified to by Dr. Ozio. Dr. Ozio, in his testimony, stated that it was a BBC movie, we have put on evidence that there was, in fact, the Billionaire Boys Club, which aired on July 30th and 31st. So I intended to get into pretty much detail regarding the Billionaire Boys Club movie, and I could say with confidence that there is no question, based on Dr. Oziel's testimony and upon seeing the movie, that is the movie that defendant Erik Menendez saw 3 weeks before the killings.
All right. Do you have that videotape?
Yes.
All right. I'll devote 94 minutes to it and review it. Again, this is an area that to some extent has to be reserved until cross-examination. Now, I can't tell you what will and will not be admissible until I hear the direct examination and see where it goes. Is there logic there, you think? So
No.
if there is, then that should answer the question, and then you should withdraw your objection to it.
I don't think there is the problem. And here's why I think it's illogical. Putting aside for the moment the prejudicial impact of trying to prove that my client modeled himself after a group of criminals, which is the real reason, I suspect, people want to use that information. The Billionaires Boys Club was a group of young men who got together and committed, if you believe at least the premise of the movie, however juries may have eventually sorted all of that out, is that they got together and committed 2 murders for money. And the real purpose of this then is to put Erik Menendez in the same category as Joe Hunt and the Dosty kid and the Eslamina kid who were involved and charged with those crimes. And that is a highly prejudicial purpose for the use. This is truly guilt, not even by association, since he didn't associate with any of the people who were in the Billionaires Boys Club, but the notion of association simply because he knew about it or saw the movie. So setting that aside for the moment, here is therefore the logical, so-called logical construct by which the people want to use it in this case. Dr. Oziel did not testify that Erik Menendez told him that he saw the Billionaires Boys Club miniseries, which is what it was. It was a 2-part miniseries. He never said anything like that. In fact, in an interview that was conducted by Detective Zoller of Dr. Oziel on, I believe, June 21st, 1993, it was clear that Dr. Oziel had virtually no idea what the content of the movie was, because Detective Zoller asked him, did this movie had anything to do with sexual abuse or child abuse? And he said at first he didn't know, and then he didn't think it did. But there was no recitation by Dr. Oziel of what the movie, if it were a movie, was about.
No one ever said that Oziel knew anything about the movie other than what your client told him.
Well, but what he says my client told him was that Erik saw a special, now a special could be anything, it could be a variety show, or a movie on the BBC, not about the BBC, not concerning the BBC, but on the BBC, which led Mr. Kuriyama and everybody else, I believe, to think that what he was talking about was an English program, either originally on or still on the British Broadcasting Corporation. That's all Dr. Oziel knew about it. That's the only identification that was made of it at that time. Now, Mr. Kuriyama finds, by his video store visit, that on July...
Well, we've been through all this, so why do we have to go through it again?
I just want to make this point. The theory of the people and the theory of Dr. Oziel was that this movie, whatever it was, disinhibited Erik Menendez so that he was now inspired. This is the light bulb going off, supposedly. He is now inspired, having gained this information about this killing by this BBC member and his cohorts of his father. This plants the seed of inspiration in Erik Menendez's head. Now, if Erik Menendez already knew Brian Eslamina, then this makes no sense. Because if he knew Brian Eslamina, a child of the family of the slain father from the BBC, then clearly it didn't take a movie to tell him about this?
Well, you're playing with the facts and arguing the case. The issue is what was said by your client to Oziel and what, if any, significance it has
All right.
extrinsic from the statement. Looking beyond the statement, looking to any other evidence that might be subject to introduction by the prosecution or anyone else. And the prosecution has a theory that when your client used the initials BBC, he was referring to this particular movie. And then they go from there to want to introduce the movie or something about it. The jury already has been informed that this was a production that was on television that related to a father being killed by his son. That's basically all, or as a son was involved in the killing of a father, something along those lines.
Okay.
And that's it. So the issue is whether or not it'll go beyond that. Again, I'll have to hear what your client has to say about some of these subjects, and I'm not going to rule on it at this stage. I will review the videotape to see its contents to be in a better position to evaluate it. But this is something that people want to go into, and it's something that we'll rule on prior to it being the subject of cross-examination.
Okay, but my concern is my client isn't going to talk about Brian S. Lamenia whatsoever. So the question is whether on cross-examination the people can ask him if he knew him solely to try to make this BBC link that has limited, in my opinion, extremely limited relevance and a very high level of prejudice.
Well, to ask that question by itself certainly wouldn't be prejudicial, just asking a question. Do you know a person by that name?
Yeah, but it has no relevance unless they intend to develop who Brian S. Lamenia is, obviously.
Well, as I said, I'm not ruling on this subject at this point. This is an area that is solely cross-examination, and why rule on it now before the direct examination even has begun? The next area is a screenplay, and what is it that the prosecution wanted to do in regards to it? Which screenplay? There's only one that related to events prior to the killing, the one that he wrote with Mr. Signorelli. And what is the defense response to that? The defense has brought out that Mr. Signorelli wrote a screenplay or was contemplating a screenplay about this case, as I recall, and also the relationship of Signorelli and the defendant, Erik Menendez, will be at issue.
I was talking about that screenplay, which is obvious since that screenplay was written before this occurred. Mr. Signorelli was going about town, as the court heard, boasting about knowledge about this case and indicating that he was going to make a lot of money by writing a screenplay about the killing of the Menendez parents. Now, I have no intention of bringing anything out of my client about that because he doesn't know anything about that. But I don't believe that the fact that Mr. Signorelli, in order to show his bias, interest, and motive to lie in this case, by making himself look like he knows and was involved in a lot more than he was, by writing screenplays, gives the people the right to ask my client about basically the content of the screenplay that he wrote with Mr. Signorelli that this court previously ruled was not sufficiently similar and had too many totally irrelevant and complicated facts to be introducible by the people in their case in chief to show my client's so-called state of mind, particularly since it was written in January of '88. I would point out it is the people who were permitted to elicit over my objection from Mr. Signorelli that he had done any screenplay writing with Mr. Menendez at all. I objected. The court overruled it because we didn't get into the content.
Well, obviously, it's not prejudicial, the fact that they wrote a screenplay, and anybody looking at that sort of evidence would not find it prejudicial. The fact that two people sit down and write a screenplay is an example of perhaps their relationship or part of their relationship. So the fact that that occurred is not prejudicial in any way.
Okay, but
As far as the content of this screenplay, again, I don't know precisely what it is that your client is going to say about his relationship with his father, his mother, and other matters that might arise during the direct examination and even during the cross-examination. It's possible that this area will come up, but before it being raised by the prosecution, they're going to have to give notice for an offer of proof. The court has made a preliminary ruling on this subject, and that ruling will stand. But before the area is brought up by the prosecution, we'll discuss it. But at this stage, without knowing what your client is going to say about all sorts of things that might bear upon the screenplay in some fashion or vice versa, I really can't evaluate whether it could be brought out during cross-examination.
With respect to Craig Heinberg and Darian and Pollock, I don't think we need to waste any time on that. Those are rather minor matters, and they may not come up in direct. So I don't think we have to waste some time discussing those.
Well, are you going to bring them up in cross-examination?
I don't intend to at this point. I merely gave them notice of the potential for that, depending on what the direct examination, how it comes out.
So you have no intention, as you sit there now and as you contemplate your cross-examination, of bringing those two up?
No, not unless he makes statements to the extent that he didn't do anything for the money, that he wasn't interested in money, that sort of thing, then these things may come into play.
Well, I can assure Mr. Furiama that my client is going to testify he did not kill his parents for money. I think that's pretty obvious. But I don't see how that suddenly brings out this.
All right, so how does that change your approach, if any, regarding cross-examination, now that you're informed that Erik Menendez will deny that he committed this crime for money?
And that he has no interest in money, I take it?
Ever? You mean even to eat?
All right, you're saying that this might be evidence in relationship to some evidence that was already introduced dealing with the defendant not having any interest in money and not being concerned about money and wanting to set up some sort of foundation and all that stuff.
Right, according to Marta Cano's testimony.
All right.
That doesn't have any bearing on the Heinberg thing, or there's no thefts involved with Mr. Heinberg.
I thought you said there was a wallet and a credit card taken.
It's a very garbled story, but theoretically, what it means is that Erik was pulling a prank. He looked through Mr. Heinberg's wallet and flipped his MasterCard into Mr. Heinberg's backyard. That's what that incident's about.
Well, I guess the people in Calabasas thought that there were pranks being played too, but I guess it's all within one's perspective. I don't know the
Mr.
details.
Heinberg didn't go to the police and complain, so he knew it was a prank. I mean, he knew it was a joke.
If I may, counsel knows that there is a report indicating that Craig Heinberg's house was broken into, a window was smashed. Erik Menendez entered that house, and when Craig Heinberg returned to his house, he went into his room and found that his credit cards were all in a different place and all, I guess his room was disheveled. So that's I think, the point that I wanted to get across, that he broke into this man's house and did something with his credit cards.
Is there any detailed interview of Mr. Heinberg, or is it something that is reflected in someone else's statement?
There's actually, I can provide, yeah, he was interviewed. There is an interview of Craig Heinberg. I can provide that to the court. I don't have it with me
Does
right
counsel
now.
have it?
Yes.
I have our interview with Mr. Heinberg, which I would submit to the court in camera. Since we're not calling him as a witness, there's no reason for us to give discovery of it.
Well, if you want me to consider it for some purpose, then you'll have to give it to the other side. I'm not going to view something one-sided here that the other side won't have a chance to respond to.
Well, Your Honor, this, if they're talking about this in the notion that it is some sort of burglary or criminal act, then I really think that the rules of 1101 still apply. And there's no similarity there to anything with which Mr. Menendez is charged in this
So I
case.
said, I don't know the facts, and that's.
Mr. Heinberg, well, let me just float
I
a
asked you for
problem.
the report. You have
He has it.
interview from Heinberg. You say you have something that puts it in a different light. If you want me to look at those, I'll be glad to do that.
I don't have it with me. I'll have to give it to you on Monday, Your Honor.
And again, is this something that is definitely going to be coming out, or is something that, as you have now heard the defense offer, is still problematical whether you bring it out?
As I sit here today, I'm not sure whether I'm going to examine the defendant on that matter. I'm going to wait to see what the direct examination is.
And in regards to this last item, dealing with some rip-off so-called ripoff of $40,000. Is that an area that you would be going into?
That had to do with, I believe, it was $40,000 that Erik Menendez had invested in a concert promotion.
No, I'm asking, are you going to go into it?
Well, it depends on his testimony in direct. If he's going to say, I wanted to put all my money into charity, I wanted to help the homeless, this may become relevant. That something like this, investing money for these concert promotions, in addition to the November 29th, 1989 statement in which he talks about buying multi-million-dollar houses in Beverly Hills, I think that contradicts what previous witnesses have testified as to.
But you're not offering it based upon what previous witnesses have said, but only based on what he might say in his direct
Right.
examination.
That's right.
Okay. All right. So prior to that being an issue, again, we'll have notice by the prosecution. I don't know the details of this. I've seen mention of the names in certain documents, but I don't know any of the details. So if you want me to look at the Heinberg material, I'll be glad to do that. I'll look at the videotape of the movie that was referred to. What else do you want to discuss in relationship to the defendant's examination? I think there was reference to some report prepared by Deputy Vera.
I'm just making a discovery demand on Detective Zoller, that I have a copy of this report.
What is this all about?
Well, I don't know, since I haven't seen it, and if the court wants me to give the court what I think it's about, I would prefer to do that in camera.
What is the response of the prosecution?
Your Honor, there, I don't, there is a report that's in the process of being completed regarding information from Deputy Vera about Erik Menendez's, how should I put this? Activities.
Not put it.
Okay, he
I'll
is
just say
a
activities.
deputy sheriff you're talking about?
Yes, Your Honor.
And this is something that is a potential witness that the people might be calling?
Potential witness, and it's only possible impeachment based on what Erik Menendez testifies to, which we don't know what he's going to testify to. So at this point, it's merely possible impeachment of Erik Menendez.
Okay.
Since they're out beating the bushes trying to scare up witnesses on this issue, and I've heard about it that way, I would like to see what this report is so I can properly prepare my client should he be asked about it.
Well, they don't indicate that they're going to ask him about it until they know what he says on direct
Yeah,
examination.
well, I mean, but you know, under 115, we're supposed to be given rebuttal discovery before we put on the defense. It's not supposed to be.
Well, they're not saying this is rebuttal. They don't know what it is that you're putting on.
I'm not, well, I would like to approach and be heard in an in-camera setting to let the court know what I understand about this so that the court can understand our sensitivities on it.
Sure.
Thank you.
I'll let both sides approach. I'm not going to do a six
Obviously, they know
party.
more than I do.
Well, I'm not sure about that, but both sides can. As prior to the commencement of his examination on Monday, other than the matter that we were discussing at sidebar, is there anything else that council want to discuss? Okay, and yeah, I understand. Now, as far as the defendant, Lyle Menendez, there was a memorandum filed on his behalf requesting the court to look at again the issue of whether or not Erik Menendez should be permitted to testify over Lyle Menendez's objection before the Lyle Menendez jury. And I have read the brief filed by the defense. And are you prepared to argue the matter further?
Yes,
Okay.
Judge, there's also two other cases that I wanted to cite to the court on this issue. One is which is 48, page 1222, and the other is People versus Clark, which is 50 Cal 583. And both those cases.
Those are pro per cases, were they?
Both those cases deal with a situation where the defense, the client, is been convicted, and he's saying at the penalty phase, over the wishes of his lawyer, I don't want to present any evidence during the penalty phase. I want to receive death. And the lawyer is standing up and objecting and saying society has a strong interest in getting at the truth because death is the ultimate penalty here. And I'm going against the wishes of my client, and I want to present mitigating evidence. So it's a conflict between those two values. And Bloom establishes, as described in the Clark case, notwithstanding the state's significant interest in a reliable penalty determination, a determination best made by a fully informed sentencer, a defendant's fundamental constitutional right to control his defense governs. And then the Clark opinion cites Bloom for that same result. And the court also considers the question of whether Feretta applies to the penalty phase, which would have seemed to have been decided in Bloom. The court discusses the issue again. It says that nothing in Feretta implies such a limitation. And both the common law and constitutional history on which the United States Supreme Court relied support our conclusion that the right is absolute. And I would suggest to the court that
Well, that issue had been resolved in the Crandall case as well as
Right.
to appropriate and penalty phase.
my point in citing these cases to the court is there are very few rights that our present Supreme Court has ever described as being absolute. And I think the court's conclusion in the Clark case that the defendant has an absolute right to present his defense in the way that he chooses is important in this context as well that we're discussing. So I bring that to the attention of the court, and I think it's supportive of the other cases that we cited. I've said to the court I don't think these cases are precisely on point, but I think the analysis is on point in that the court is asked to consider, first of all, whether there is any infringement on the defendant's right to present his defense in the way that he and his lawyer choose. And second of all, if there is infringement on that right, is there some interest or justification sufficient to outweigh the defendant's interest in conducting the defense in the way in which he chooses to do? And our position to the court is that the interests asserted in these other cases are certainly as strong, and in the case of the Clark and Bloom cases, much stronger than the interests being asserted by the prosecution here in support of a rule which forces Erik Menendez to testify while defendant Lyle Menendez is presenting his defense.
That would happen, would it not, in any multiple defendant case before a single jury where the defendant or more than one defendant testifies? It always happens during the defense phase of the case, does it not?
The defense phase of the case, that there's this conflict?
No, that there is testimony by more than one defendant, and it always happens during the defense phase of the case. So why is this different than any other case where there was more than one defendant on trial?
Well, for a number of reasons. First of all, in this, if I could go back to where we started this case, which is in the single defendant mode, it's my recollection of how we came to the situation we're in now with two juries, and I think the court has alluded to this before, that the prosecution was essentially put into a position that they may have lost certain evidence if they had proceeded with a single jury. And the court gave them the option at that point of whether they wanted to gamble on that possibility or instead whether they wanted to go ahead with two juries. They chose to go ahead with two juries. Had we gone ahead with one jury in the case, the people's evidence may have been restricted in ways that do not duplicate the situation now before the court. And if, for instance, the court had ruled certain evidence and testimony inadmissible, the defendants in this case would have been faced with a much more difficult decision as to whether or not to testify to begin with and as to how their defense should be structured. Even if they had gotten all the evidence that is presently before the court into the record somehow. And I suggest that that's really a hypothetical situation. It would still be the case that the defendants would be able to put on their defense in the way that they chose during their case in chief. And if it happened that while Lyle Menendez, for instance, if Lyle Menendez went first in a single trial and he testified as he did here over the course of 7.5 days, Erik Menendez at that point would have been in a position to object to any testimony being presented by Lyle Menendez as irrelevant to his defense. And then suppose after Lyle Menendez testifies, Erik Menendez goes ahead and testifies to a defense which is antagonistic. If he had done so, and if Lyle Menendez had objected to that testimony as irrelevant, the court would overrule those objections because it's certainly relevant testimony since it contradicts evidence which Lyle Menendez would have been giving in front of the single jury. The problem is that those antagonistic defense cases don't work in this case because here the defenses are not antagonistic. And in fact, they are joint defenses in the sense that both brothers, as we anticipated, would testify to essentially the same sort of testimony. But in that situation, because state of mind is an issue as to both defendants, Erik Menendez testifying in front of a joint single jury, for instance, could go into sexual abuse that he suffered at the hands of his father outside the presence of Lyle Menendez, and which was not related to Lyle Menendez in a conversation. That testimony is technically inadmissible against Lyle Menendez, and theoretically, Lyle Menendez could stand up and object.
Are you saying that Lyle Menendez would not want his jury to hear that evidence and that he would be prejudiced by this jury hearing it?
He would, and the reason he would, and this is a matter of trial tactics, but it's our view that because the sexual abuse suffered by Erik Menendez extended over a longer period of time and is much closer in time to the time of the offense, that it's prejudicial for two reasons. Number one, if you look at how long the direct and cross-examination of Lyle Menendez took, the mere repetition of abuse testimony is, in our view, and we may be wrong about this, but this is just our view as defense lawyers, it may have a numbing effect on the jurors. To a certain extent, they may, after hearing so much testimony about abuse, in our view, be turned off by that sort of testimony, and at some point it tends to lose its emotional impact.
You didn't have that view when you're introducing the evidence up to and including the time your client took the witness testimony that preceded it.
It's a delicate balance, and it wouldn't have been enough just to put the client on. We believe that the other evidence was cooperative and necessary, but there does become a point where, in our view, it would be numbing. And then the second aspect of it is that, and this is something we raised in the severance motion for a different argument, which was the penalty phase implications of this, that our jury would sit there and listen to Erik Menendez's testimony and compare and contrast the abuse which was inflicted on him and say that, well, that abuse was much greater than inflicted on Lyle Menendez. He's the older brother. As we all know, or as we all assume, older brothers are more responsible. Since his abuse wasn't as great as Erik's, we're somehow either consciously or unconsciously going to hold that against him. And we submitted to the court some empirical evidence in support of the fact that jurors do think that way. So the second concern on our part would be that the jury would be doing that. In a joint trial, we could stand up and object, and technically the court could say, yes, this evidence as to Erik Menendez is only coming in as to Erik. The jury should not consider it against Lyle. That would not be a perfect solution because obviously they will have heard it, and a cautionary admonition in that situation is not the ideal situation to deal with that problem. Going beyond the single jury situation, as the court said when we were discussing it before, the difference here is, and the court articulated well our position, which is the position, and this is at page 13,845, the position of the defendants that they have two juries they have an opportunity that wouldn't exist in a one jury situation to testify only before one jury rather than in a joint trial where one jury decides as to both defendants. So, yeah, we could compare hypothetically what could happen in a single jury situation, but the fact of the matter remains, as a result of really the prosecution's choice here, we do have the opportunity to lessen the impact and so it's our position that in that situation, and given the posture we're in, the interest of allowing us to conduct the defense in the way that we choose is best fulfilled by allowing us the option of not calling Erik Menendez, in our case, in chief. The people's interests in that situation are fully protected because that position allows the people to wait and see what's developed during the direct testimony of Erik Menendez in front of his jury. And just hypothetically, suppose, despite the opening statements of both counsel, Erik Menendez said, "You're right, we did it for the money, and everything you say is true. And in fact, Lyle was the heavyweight in this and made me do all that." Suppose that happened. The people in that situation would then be in an excellent position, it seems to me, to argue to the court that that testimony was admissible in rebuttal to Lyle Menendez's testimony that he gave during his direct testimony during the people's presentation of their rebuttal case. And then the court would be faced with a situation where the court can control the scope of rebuttal to admissible evidence. And the alternative is that we gamble that Erik Menendez is somehow going to develop some testimony that would technically be admissible in the rebuttal case against the case for Lyle Menendez. Has been our position from the beginning is that there is no conflict in the defenses. Implement Lyle Menendez, but will cover issues that are unique to him, and that to force us to sit through that, and our jury to sit through that, is interfering with our right to put the defense on in the way that we choose. And again, the people, Ms. Bazanich says, the people's response is that is acceptable. That's at page 13904. So in terms of balancing the interests here, which the courts have done in these cases, I think we have a strong argument, Your Honor, that our interest in putting the defense case on is being infringed here, and that there is no justifiable reason for not adopting the normal course of allowing the defendant to put on his case in the way he chooses, and then allowing the people to rebut that case with, at that point, whatever admissible, relevant evidence they have at their disposal to use, including the testimony of Erik Menendez. And then the last consideration I want to point out to the court, which is something which just arose today, is counsel for Erik Menendez indicating in order to testify. And given that fact, it's our concern that makes the situation of his testifying even more unpredictable from our standpoint, from Lyle Menendez's standpoint, and we shouldn't be forced to bear that risk.
All right, do the people wish to respond?
Very briefly, Your Honor. I'd just like to cite the court to a footnote, which I've discovered in the
Case of People versus Keenan, which is 46 Cal 3rd, 478. At page 500, the court was discussing the issue of severance of defendants pursuant to Penal Code Section 1098. And in this particular case, it was a question of antagonistic defenses where one defendant was going to present evidence of the co-defendant's prior criminal activities to support a duress defense in a robbery, which resulted in a murder. And in footnote 5, the second sentence, it says, the Supreme Court says, "We are aware of no principle which gives defendant the right to insulate himself by the tactical device of severance from the relevant and admissible testimony of his co-defendant. And I think that sentence sums it all up. In spite of this rather elaborate argument made by the defense, there is no reason that both defendants shouldn't testify in front of each other's juries. This is a single trial. It is a single proceeding. It is not, the two juries are the exception to the rule. They are not the rule in this particular trial. And much of the evidence presented by the defense has been in front of both juries, even if relevant to only one particular defendant. I think that the sentiment expressed in the Keenan court, which is that there is no authority to grant the defendant the right to insulate himself from his co-defendant's testimony, applies in this case.
Can I respond just briefly to that?
Yes.
Which I think that case does, and the sentence she quotes emphasizes relevant and admissible evidence, correct?
It says relevant and admissible in italics.
Right, and our position is that that's right. We're not seeking to insulate ourselves from relevant and admissible evidence that the people can offer by Erik Menendez against our client. What we are seeking to insulate is the prosecution dictating to us how we can put on our defense. We leave the option open to the prosecution to produce whatever relevant, admissible evidence they want to produce during the rebuttal case. And in the Keenan case, it was a case where the co-defendant essentially said, the other guy made me do it. And again, if that was the testimony by Erik Menendez, we would be in no position to say that was not proper rebuttal, because Lyle Menendez would have testified in front of his jury to a contrary version. The people would be in a position to offer proper rebuttal. But what position could the people offer if they were simply seeking to put into evidence during their case in rebuttal 6 days of testimony, which was completely consistent with Lyle Menendez's testimony? It would be our position in that situation that testimony should be excluded as undue consumption of time under Evidence Code Section 352, and not proper rebuttal, because the testimony doesn't rebut. It corroborates, and therefore that's an improper rebuttal situation. So we're not asking the court to exclude any admissible relevant evidence. We're saying to the court that the court should not assume at this point that Erik Menendez is going to offer proper rebuttal evidence and allow the people to go ahead in front of our jury at a point in time when we're not done with presenting our case in chief.
All right. This case, by its presentation here and the evidence that has been offered by the prosecution and the defense, has some unique features to it. Principally, the allegation is, and the evidence that's been offered has been, that this was a incident that was committed by both defendants, or a killing that was committed by both defendants together. The evidence that related to the commission of the act, that preceded the act, related to both defendants, was introduced as to both defendants. The evidence relating to events subsequent to the act related to both defendants. The evidence that's been presented by the defendant, Lyle Menendez, so far is evidence that relates to both defendants. I agree with the analysis so far from Mr. Burt that there is no conflicting defense here, but whether there is a conflicting defense or a joint defense, if there was a trial with one jury, both defendants would be testifying before both juries. And that is all that is happening here. And it would all happen during the defense phase of the case. Both defendants would be testifying, if they chose to testify, before the jury at this during the defense phase of the case. And that is what we are seeing here. And the defense of each defendant is getting the benefit of a separate jury to deal with those matters that are prejudicial or inadmissible as to one defendant or the other, by reason of the fact that we do have two juries. And when those matters arise and are subject to litigation and objection and ruling by the court, then one jury hears it, the other jury doesn't hear it. So the defendants are getting the benefit of two juries in that regard. Just to repeat again, this is nothing unusual that two defendants or more than two defendants would be testifying before the jury at the same time during the defense. And it is not a an interference with the defense right to put on its defense. It happens every time there's a multiple defendant case, and this is no different than that. Because of the unique features of this case, the court has previously ruled that in regards to the testimony of Lyle Menendez, that be before both juries, and the court similarly rules that the testimony of Erik Menendez be before both juries. I've made previous statements and explanations as to my reasoning in that regard when the matter arose prior to the testimony of Lyle Menendez. I reiterate those at this time and repeat again that since there is no antagonistic defense in this case, there is nothing that has been presented to me that causes me to believe there's any prejudice suffered by either defendant by this process. But because of the joint defense that's been presented, it seems to me that the juries will benefit from the entire picture that's been presented by the testimony of both defendants in this regard. The defense stated its objections to that view, since the defense feels it has the right to call which witnesses it wants to call during the defense, and it's certainly not the province of the court to make that decision. I agree with that, but to reiterate, this would be no different than any other trial where there was a single jury and multiple defendants who testified before the single jury. And I don't find that there's any deprivation of the defendant's right to counsel or right to a jury in this matter, right to a fair trial in this matter. So the request of the defendant, Lyle Menendez, to be absent and have his jury absent during the testimony of Erik Menendez is denied. All right, anything else now before or is there anything else the council want to discuss before the testimony of the next witnesses? All right, there was the matter relating to the letters or the box of documents that was turned over by the defense. Is that something that you still were considering, or you?
We still need to discuss it, Your Honor.
Okay. All right. I'll have the court reporter read back to me or prepare a transcript of those few questions and answers so I can deal with that on Monday as well. All right. Anything else now before we recess? Huh? Oh, I bet you have already seen it. All right. All right. All right. There'll be a run on it tonight at the movie store, the video store. Yeah. Okay. We'll be in recess.